Like Richard, I could be persuaded, but I'm not sure I entirely was by the 14th Amendment discussion. You suggest that the power of locomotion and the due process clause may give rights to people outside the United States. I wasn't sure that it applied to people outside the United States. After all, you might say, well, that's the word, but what about the context? The context of the preamble seems to suggest this is a constitution about people who are connected to the United States. I'd like to hear more about that. With respect to your discussion of the representation reinforcement theory of Ely, I have a sort of similar reaction. As I remember, the theory, it's about democracy within the United States. This seems to be a kind of extension of that theory. I wonder more generally about the paper, as you sort of thicken some of the originalist arguments, whether it might be better to leave that out. I think one problem, particularly as originalism scholarship has sort of advanced, is it doesn't want to appear sort of on its face like an advocacy piece, and having a variety of arguments that aren't originalists tend to give that a kind of optics, whereas I think we're just trying to find the empirical facts regardless of our normative positions, and so I think it's good to separate that out. So that's just a structural suggestion.
So I consider myself sort of sympathetic to the sort of general thesis here, but I guess I have a sort of different version. I've actually thought about writing a paper like this for several years. I just figured there was just too much work involved, I thought. But I've got some pages written. But I guess my take on it is, I think that there's no general power over immigration, but the federal government has lots of powers that go to portions of the immigration power. And I felt like in reading this, you were just trying to knock down everything, kind of. They don't have this, they don't have this, they don't have this. So just, for example, and the reason they didn't have a general immigration power is, they weren't really worried about immigrants. They wanted more immigrants. On the other hand, the federal government presumably would have power over the borders where they had territories, right? So they would have some power there. I think even under a sort of narrower understanding of the Commerce Clause, that Congress could prohibit, let's say, buying a ticket on a boat coming in from another country. That wouldn't allow them to stop everything. You could come in on your own boat. you could walk over. So you can just go through. There's lots of different ways of thinking about this. Maybe Congress can, if Congress has eminent domain power, could build a fence from buying land along the states and then build a fence that way. So on the one hand, there's not any general immigration power. On the other hand, I think there's a lot of individual pockets of it. And at least my version of it would be to not to try to push it in one direction or the other. I think sort of generally the piece, it's, what is it? It's 35, it's whatever it is, 45 pages, double spaced, covers a lot of ground. I think, it depends how long a paper you want to write, but it's really covering a lot of different issues. To do a kind of thoroughgoing originalism would require more effort. You might want to say, I can't, treat all these issues in depth, and this is just going to sort of, be a more cursory analysis to deal with it. Finally, I guess on the Hamilton point, this is sort of helps and hurts on the Hamilton point. If memory serves, Hamilton, in the Bank opinion, says that proper, speaks separately about proper, but I think he says something like it's it's sort of, violates moral norms or something like that, which would be different than a great power understanding. So on the one hand, he would have a different understanding of proper, but on another hand, it might not signify great powers.
My question is, I really enjoyed the paper. I thought this was really interesting, and I learned a lot. But to kind of play devil's advocate, I want to press you on what you said you didn't want to talk about, which is what to do about it, or maybe more precisely the consequences if we went down this road. And it strikes me that it would just be practically completely impossible unless I'm missing something. I mean, if it meant that Rhode Island could open its borders and charge a lot of money for it and just have a conduit there, you'd have people going to every other state within a half an hour. That it was the original, at the time of the founding, people couldn't have conceived of because of the changes in transportation and the number of people and everything. The world has gotten smaller. So I guess the question would be, couldn't someone see this, a non-originalist might see this as a kind of reductio of originalism? Think of David Strauss, he begins his book by talking about one of the problems with originalism is, look at all the things that we wouldn't exist in the world if we were faithful originalists. And I could see him adding this to the list. If we follow the reasoning that Mitch was suggesting, it's sort of a fixed point that would sort of falsify the theory that leads to it, unless supplemented by something like Will was suggesting, a very thick understanding of practice being consistent with originalism. So that's just meant to be a kind of provocative suggestion. I'm curious if your response.
So let me work back in reverse order on these three questions. On your question, what if there were horrible practical consequences to this? This is a sufficiently big issue. I'm actually writing an entire book devoted in part to this question called Foot Voting and Political Freedom. For now, I would note merely that there are horrible consequences from our current immigration regime in that millions of people are condemned to lives of horrible third world poverty and oppression as a result of it, and millions of native-born Americans also have their freedom restricted in various ways. And while I would never contend that there are zero negative side effects to open immigration, I think many of them can be handled by mechanisms other than sort of restrictionism of the kind that we've seen. So there's two sides to this question. If originalism, I would argue ultimately if originalism gets us to a regime of closer to open borders, that's actually a feature rather than a bug of originalism from a practical consequences point of view. But I don't think fully entering into that is something that I could do in this paper, because as Mike quite rightly pointed out, there are already some other issues that are more narrowly legal issues need to be dealt with in more detail, and to also deal with sort of policy questions. So what I may do, include a paragraph saying like, some of these policy questions I'm dealing with in some of my other work, and I actually already note that a little bit, but I can say it more. Regarding Michael's comment on Hamilton, I do need to look again at that particular passage in the report on the bank. Though I do think that what he said in the Federalist Papers at the time of debates is probably in some ways more probative of original meaning, and that doesn't seem to refer to moral principles, unless you think that interfering with state inherent laws and the like are somehow inherently immoral. I too may be having issues with my handwriting, so I will return to Mike's other comment if I can decipher my handwriting here. This seems to be a common problem even for people who are textualists, perhaps especially for them. On John McGinnis's comment about whether the 14th Amendment and perhaps constitutional rights in general refer to people outside the United States, I would merely note that the 14th Amendment refers to persons without geographical specification, at least in that respect, and that most of the other rights in the Constitution also generally read as limitations on government power rather than as protections for particular groups of people in particular places. And therefore, I don't think it's desirable to read in these limitations unless there's some strong evidence, originalist or otherwise, as to why we should read into it. There are some rights that are specifically reserved for citizens, like the Privileges or Immunities Clause and the like, but that only emphasizes the fact that other rights are, in fact, not specifically reserved, indeed read as limitations on government power rather than as specification for particular people. Regarding the preamble, this is something I was going to include in the paper but didn't include, but John's comment reads me to think maybe I should have included it nonetheless. And the preamble actually refers to the people in our posterity. And I think posterity clearly is not meant to refer merely to the sort of the biological descendants of the people in the U.S. at the time. It's to all people who may come in. And therefore, I think that fits the broader 18th century Enlightenment vision of the world that the preamble refers to. So maybe this doesn't matter too much to people who don't think the preamble is binding, and I don't necessarily think it's binding myself, but to those who do, I think this broader interpretation is more persuasive than the sort of narrower, more sort of exclusionary one. I had thought to include this, but I hadn't yet, until this moment, I hadn't seen this brought up in sort of debates among constitutional theorists, though I do see it on immigration restrictionist websites where they say it's okay for us to restrict immigration because the Constitution is only about Americans and their posterity. So maybe I will include that because this argument may have more purchase than I originally thought it was. Finally, on Michael's comment that I temporarily forgot about but now can decipher my handwriting on other powers and their relationship to immigration, I do mention several times in the paper that there are some powers that might enable the government to restrict some types of migrants. I don't think this adds up to a general power to restrict all or most migration, and I give some answers in some particular places to why that isn't the case. I'm not going to summarize all of it. It's probable that I need to expound some of it more, but the short answer is that most of these powers just relate to excluding people who are engaged in particular types of activities or banning the activities themselves, a point that Albert Gallatin, who I quote, made in the debate about the Alien Friends Act. Others, yes, in principle, you could say they could try to build a wall or a fence or whatnot, but I think if the purpose of the fence is to accomplish a power not otherwise granted to Congress, then it's in fact pretextual and it would become the duty of the court to strike it down, to paraphrase a famous line from McCulloch. And granted, there could be borderline cases, both literally and figuratively, where it's not clear what whether this is pretextual or not. But I think if you allow all pretextual uses of powers, then not just this limitation, but almost all structural limitations on power would end up getting swallowed up. And there might be some complex questions about how exactly to cash this out if you do get to the point where we roll back some of this precedent. And in the paper, I do actually discuss some intermediate steps that could be taken short of overruling the inherent power doctrine or overruling the plenary power doctrine entirely. For example, you can overrule the inherent power doctrine, but allow exclusion of migrants that fits within the modern interpretation of some of the other powers. There's other intermediate steps that can be taken as well.
Okay, our next trio is Chris Green, Evan Bernick, and John McHale.
So war and invasion. We were talking about this last night a bit, but war powers, Congress can do it, when it's a really bad idea or violates international law. They can do it without using the word war. They can do it even though they're just trying to detain people instead of kill them. And it seems like they can do it against individuals. So if you remember Indiana Jones 3, execute the American conspirators. Germany has declared war on the Jones boys. Failed state situations. I'm sorry? Was that? It was the last Indiana Jones movie, actually. They'd never made another one. They never. Yeah, the Crystal Skull is non-canon. One of those four steps has got to be wrong for your theory, I think, but maybe it's got to be a lot of people or something. Invasion. So you've got three references. You got, the power to repel invasions. You've got a duty to stop invasions in Article 4, and you got invasions mentioned in the habeas corpus clause. Do invasions have to be violent? Can you sneak them in? Congress seems like they can exercise this power when they're paranoid. Why isn't this an invasion? Or, why isn't the power to repel invasions the power to keep people out?
So, bracketing for the moment the question of whether the term persons in the Migration and Importation Clause would have been understood by members of the ratifying public to denote slaves and only slaves, even if the migration and importation of such persons is a euphemistic reference, it contemplates that there's power to prohibit people from entering the country, which raises the question of where that power comes from and what the scope of it is. Now, I take it that you think the power comes from the Commerce Clause. I'm not sure what you think the scope of it is. I take it you don't think that the Commerce Clause authorizes Congress to prohibit people who aren't slaves from entering the country for commercial purposes. But unless Congress has some slavery-specific prohibitory power, I think you need to say more about why Congress has the power to prohibit migration or importation of slaves for commercial purposes, but doesn't have a broader power that's potentially applicable in the context with which you're concerned. The second point is you say, and I agree, that it's dangerous to assume that the president had inherent power similar to contemporary executives, but the fact that we can't assume that he possessed all such powers doesn't mean he didn't possess this particular one. And I don't know where you stand on whether the first sentence of Article 2, but if it vests power instead of merely identifying the holder of subsequently enumerated powers, it seems very possible to me that it vested this kind of power, one that was historically understood as an executive power. And your argument that, well, this is a particularly, broad power and therefore would have been enumerated, I don't think is particularly holds up particularly well, given that there are, I can think of a number of inherently executive powers that aren't enumerated in Article 2, such as the power to repel attacks, that I think that one can convincingly argue were vested nonetheless in the executive.
I'm sorry, there's one more person left. Is right here.
Yeah, John.
So, Ilya, as I mentioned to you over lunch, I really admire the way you've stepped out in front on the Trump executive order and argued for its unconstitutionality. And I think I probably, at the end of the day, agree with you, but I get there from a very different route, and I want to flesh that out in relation to your paper. So focusing on the necessary and proper clause, point one is I think you have to tread lightly when you rely on what Madison and Hamilton say in the Federalist. In Federalist 33 and in 44, neither Hamilton nor Madison quote the necessary and proper clause accurately. Both of them are playing fast and loose with the text. They are both, in my estimation, quite consciously suppressing the sweeping clause function of the necessary and proper clause. In your analysis, I don't think you're doing justice to the way that the court understood the necessary and proper clause in the Chinese exclusion case. And the best illustration of that is that in sections E and F of your paper, you are analyzing whether there's an inherent congressional power on the one hand or an inherent executive power on the other. The way the court actually does this in Chinese exclusion is that they're operating at the higher level of an inherent government power. And the text of the necessary and proper clause itself forces us to recognize a distinction between powers vested by the Constitution and the government of the United States on the one hand, and powers vested in Congress or other departments or officers on the other. That's really forced upon us by the text, I believe. And the way these late 19th century cases all worked, legal tender case, Chinese exclusion, insular cases, and so forth, is that the court began to recognize that there were additional unenumerated powers vested by the Constitution in the government itself, and what they typically said was these are incidents of national sovereignty. So the way the analysis works is first you recognize that the power is vested in the government, then you go to the question, can Congress legislate pursuant to that power, or is in fact maybe the president the agent that is secondarily vested with the power to carry it into effect. So you're conflating in your section E inherent congressional power with inherent government power. And it seems to me the right analysis is that the power most plausibly is a power vested in the United States. And the United States does in fact have, on the original understanding, all of the powers that any other nation has with respect to a limited set of national sovereign issues like immigration. I do agree with Charles, it's almost a reductio of this way of looking at the Constitution, that you don't end up with the recognition of a power to control the borders, the migration across borders that the immigration power would encompass. The last point, if I can anticipate something that Mike Ramsey might say, because I've found very interesting the posts that the two of you have put up on this, is that I don't think that the 10th Amendment poses any particular problem for this view. And the reason, it's a couple different ways to put this. Point one is there's no contradiction in thinking that among the delegated powers are what are understood to be inherent powers. That's not a contradiction. It could have been the case that the founders, when they were talking and writing about powers delegated to the United States by the Constitution or vested in the United States, that they would have included all the powers that, according to Vattel or according to any law of nations theorists, were those powers inherent in any nation. But you don't even have to bring in the term inherent power. You could just simply stick with something more modest like implied power. And you could say that among the implied powers delegated to the United States or vested in the United States is a power over immigration. If you go that route, you're going to get to an express power in Congress to legislate pursuant to that implied power. The very last point I'll make is that I think at the end of the day, you can get where you want because, of course, those exercises of power, on your view, and I think it's a plausible view, have to be both necessary and proper. So you don't end up with an untrammeled, unreviewable, plenary government power. On the contrary, you have a power that's located in the Constitution, but it's limited. So that the Chinese exclusion case and its progeny might be wrong in recognizing a fully plenary, unlimited power, but it's not wrong in recognizing a power over immigration that's vested in the government that gets us going in the first place.
So I guess I'll again go in reverse order. I'm not sure I entirely understand John Mikhail's last point in that if there is this general power that's vested somewhere nebulously in the government, then if it's a separate power of its own, then it doesn't even need the necessary and proper clause necessarily because it's a separate power on its own. It's by definition both necessary and proper because it already exists independent of the necessary and proper clause. But otherwise, I would say that while I admit it may be an oversimplification or a mistake to put this inherent power argument within the congressional power section of my paper because it could be vested in the government generally, I still think my general argument applies just as well, which is that we can't assume that anything that is inherent or that might be thought to be inherent must be vested somewhere because there's a lot of stuff that is in fact enumerated that would be more fundamental and more important and more essential than this power would be. And therefore, I think it would also be very striking if this power was thought to exist, and given its importance, it was never actually specified who would have it in any way whatsoever. That strikes me as a very huge omission, as the current president might say, and strikes me as somewhat improbable. And obviously, I would refer back to the statements by Madison and Jefferson and others during the founding era where suggesting this power didn't exist, and that was the reason why it wasn't specified. That seems to me a much more parsimonious and likely explanation of why it wasn't specified than that it had to nebulously exist somewhere, but they didn't bother to assign it to any particular branch. On the question raised by Evan Bernick about, the fact that not all powers that were considered inherent to the or prerogatives of the English executive, the English monarch, that just because not all of them were necessarily given to the president doesn't mean that this one wasn't. Here, I think I have to refer back to the sort of history and original meaning of the literature that I was responding to, including Michael Ramsey's work, where the main argument is, in fact, an argument that this must have been given to the president because the monarch. This is one of the powers the monarch generally had. If there is more specific evidence specific to this power that indicates that this power was understood to be had by the president, then I'm happy to address that evidence. But if the only evidence is simply, this was on the list of was thought to be on the list of the powers of the English king, then I think the responses that I give in the paper are sufficient to deal with that sort of argument from general inference. If there is some argument that's specific to this power, then I would either have to concede the argument or I would have to provide a specific rebuttal to that evidence. But before I can do that, I want to see the evidence on this. Finally, on the Indiana Jones / invasion point, this was in fact the third out of the 4 Indiana Jones movies. It occurs in Indiana Jones and the Last Crusade, which was later followed by the Kingdom of the Crystal Skulls. And there, I would say, I think I'm on fairly safe ground in saying that an invasion does have to be violent. I think both under the expert meaning of invasion and under the popular or non-expert meaning of invasion, that's generally what an invasion is. Yes, I know people metaphorically talk about invasion sometimes, even to include peaceful migrants, but I don't think the Constitution means invasion in a metaphorical sense. I also don't think, and as Chris and I had actually discussed this point last night, I don't think that Congress can, in effect, declare war, but in such a way that the war really is only just about migration restrictions. I think declaring war or authorizing war means a violent military conflict against the state, or at least against some collective entity that is meaningfully similar to a state, like ISIS, for example. And declaring war on an individual person, or even on the Jones boys, 2 individual people, that strikes me as unlikely to be in accordance with either the original meaning of what it means to declare war, or any sort of even plausible evolutionary understanding of the relevant international law. So it would seem to me that an attempt by Congress to circumvent the limits on its power in this area by, in effect, declaring war, but then defining war narrowly to mean immigration restriction, I think that should fail even more clearly than some of these sort of pretextual uses of power that we talked about earlier with sort of, building a fence or the like. And I would use this opportunity to make a similar point about inspecting or keeping out goods and so forth, that you can certainly keep out goods that failed to pay a tariff and penalize individuals who disobeyed the relevant tariff laws or whatever. But if it's pretty clear that the purpose of this is just to keep out migrants under the pretext of enforcing tariff laws, then that would be outside the scope of Congress's power. As in every area, there's going to be difficult borderline cases, and different people can differ based on what you do with borderline cases. But if we're at a point where the main thing under debate is how to deal with the difficult borderline cases, then I will have won like 80 or 90% of the ground that I'm contending for, and I will be well content if we move the debate if the debate ends up in that kind of area.
All right, the next trio is Guy Barnett, Michael Ramsey, and me.
Okay, so I had 3 quick questions here. One of the first ones is actually a comment. You mentioned use the phrase "third world" several times, and I know that's apparently offensive now. So that's something not to be used anymore. I was told this is a political science conference about 10 years ago, so it's developing, I guess, and not third world. Second, would you concede then, looking at the broader powers, of the executive, and we're talking about these inherent ones, and you said that the executive does, or the government, I guess, generally does, have the executive, especially to exclude enemies under his powers, legislature of terrorists, and so would it be something where they could perhaps take larger swaths of people, and I'm thinking of Trump, obviously, here, with a certain migrant population, and say, we don't know who the terrorists are, but they're in that group, therefore they can't come in. Is that not surgical enough? I guess that's my question is, could you count all of that as enemies until they find out otherwise or something? I guess that's my second question. Third one, and this is just I don't know, is there another country on the earth that cannot restrict immigration? I don't know if I've ever heard of one. So I just wondered, because America would be quite an aberration if that was true, if we're the only one. Yes, exceptional. I'm sorry. What was I thinking? That's right. So, sorry. All right, that's it.
Oh, well, thanks. So I agree with some parts of this paper and don't agree with others, and so I'm going to pick on the part that I don't agree with. But I do like the rejection of plenary power, and John McHale is right to anticipate that would be my view, but I won't get into that right here. So I just wanted to ask a little bit on the executive power point, which is increasingly my view, that the power, at least to exclude aliens, was clearly an executive power under the British Constitution. And it connects up very closely with the idea of the president or the executive having foreign affairs power, because the relationship between the aliens who might want to come in and their place of origin was very much understood as a foreign affairs matter in the 18th century, at least. That you would talk about whether you would, for example, admit merchants from a particular country as a reciprocity measure, for example, or as a goodwill measure. So it was part of the president's foreign affairs power. Part of the king's executive foreign affairs power. So the question is, did that carry over to the United States under the Constitution? And you could reject that by rejecting straight up the idea of the vesting power of foreign affairs. But then you just get into a separate question that we wouldn't want to get into. So assuming that the proposition that the vesting power vests foreign affairs power is a general proposition, then the question is there reason to think that it doesn't vest this particular foreign affairs power? And there might be, but that seems like that's the way that the question would be teed up. And then the question specifically that I wanted to take up was on the Alien Friends Act. And it seemed to me that in thinking about that act and in your discussion of it, you might want to distinguish between two different powers. And one is the power to exclude aliens who are not currently in the country. And the other is to expel aliens who are currently in the country. And my impression, but this is just a question, I guess, at this point, is whether it's not the case that the debate over the Alien Friends Act was principally on the latter point. That is, there were aliens in the country that the Federalists wanted out because they thought they were disruptive, and the Republicans wanted to keep them in because they thought they were supporters of the Republicans, and not to be too cynical about things. And so, if that was the central question of the Alien Friends Act, then it does seem to me like that's sort of a different question, because there's some good reason to think that the control of aliens within the country might well have been viewed as a legislative power rather than an executive power, or at least a power protected by the Due Process Clause. I don't know what the English system, what the English law was of control of aliens that were currently in the country, but that would be something to look into. And if that's true, then that would not. If it's true that that's what the debate over the Alien Friends Act was principally about, then that would not carry that much weight on the question of the president's power to exclude aliens who are not in the country. So I think that more development of that debate would be useful on this point.
So my question pertains first to this sort of syllogism you set out a couple of times, that if the power to regulate foreign commerce allows Congress to forbid the migration of workers, it would also have the power to restrict interstate migration. So this equivalence, you draw a lot on the fact that commerce applies to both interstate and foreign migration, and I think that it could be the case that commerce that applies to interstate migration, but Congress doesn't have the power to limit interstate migration, not because it's not commerce, but because of other reasons that are situated elsewhere in the Constitution, like due process reasons or whatnot. I mean, I know that there's some doctrine in some circuits that recognizes a right of freedom of movement as a constitutional due process matter within the state. Probably there's similar lines of doctrine that apply to interstate travel. So I don't think you need to. I don't think it follows that that commerce can't include migration just because that might prevent. That might also apply to interstate movement.
Is that three or?
That's three.
Sorry,
Yeah.
I'm starting to, in addition to having trouble reading my handwriting, I'm also having trouble counting. So let me again work backwards. I think it is probably the case that I should at least briefly discuss other doctrines that could potentially limit Congress's power to constrain interstate migration. Here, I would note that obviously the due process constraint only restricts this, if it restricts it at all, after the enactment of the Bill of Rights, and it's noteworthy that the fear that Congress might restrict interstate movement was not raised, as to my knowledge, in the attack by the anti-federalists on the Commerce Clause and other things, even though obviously they raised every conceivable objection that they could think of in regards to there being excessive federal power. I'm also not convinced, though this needs more research, but I'm not convinced that the antebellum understanding of due process included included forbidding restriction in interstate movement, but this should include additional research before I could make any kind of definitive statement on that. On the question of the foreign affairs power, first I want to thank Michael for clarifying that part of his argument for me better, and I do need to answer it in that form. But I think the answer would be similar to the one that I gave, in that just as we cannot presume that anything that was considered an inherent power under the of the British monarch therefore was in the hands of the president, we also can't assume that anything that was part of his foreign affairs power specifically was given to the president, and this is so for two reasons, one general and one specific to immigration. The general one is that there are other things that clearly are part of foreign affairs power that are included, specifically enumerated, that wouldn't need to be enumerated in Article 2 if there was a general foreign affairs power, such as receiving ambassadors, for example, is an obvious case. Possibly the commander-in-chief power might be thought of this way as well, though that may include domestic command of the armed forces also. Then the general point is that many of the founding fathers, as my discussion of Declaration of Independence indicates, they actually denied that the king had this power over entry and the like. They complain about him restricting it in Declaration of Independence. They may have been wrong in their interpretation of the British unwritten constitution, if you will, but obviously their views are the ones that were more likely to be incorporated in, or as a background understanding of the Constitution, than what the British were actually doing. On this question of the Alien Friends Act and the distinction between the power to exclude and the power to expel, I think this is a distinction I can discuss, but I think it ultimately turns out not to be the one that was at issue in the debate, and I say this for a couple reasons. One is Madison and the others repeatedly argued that the federal government generally did not have this power, not merely that it was the president who didn't have it. And secondly, much of the discussion in Congress over this and elsewhere clearly seems to be talking about expulsion and exclusion together. For instance, I quoted Gallatin's discussion of the commerce power and excluding merchants who were bringing in goods that violated tariff regulations and the like. So I think therefore that these were viewed as sort of running together, and that the power to expel also was a power to deny entry at the border. And I think certainly if any alien that the president could expel under that act, he could probably deny entry to at the border as well, though I admit that given the technology of the time, there wasn't that much in the way of sort of border posts or whatnot that were run by the federal government. On the questions raised by Guy Burnett, I'm going to pass on the thing about the offensiveness of the term third world or lack thereof. To my mind, what is offensive is not the term, but the conditions that people are forced to live under in those areas. But people can agree to disagree perhaps on the terminology. On whether there are other countries that have open borders, the answer is yes. Argentina has actually adopted a generalized policy of open borders, much like the one that I advocate. And you can say, well, the fact that it doesn't seem to have harmed Argentina doesn't mean it won't harm us. It is not my claim that that I can definitively prove that by the example of Argentina. That's why I'm writing an entire book about this subject. But more generally, we can look back at our own history that we had, at least with respect to the federal government, pretty much open borders until the early 1880s. And even after that, we had open borders to all but Asian immigrants. And the same thing was true of many European countries up until the early 20th century. So I'm not claiming that this refutes all possible arguments how conditions are different today, so it would be terrible today, even if it wasn't terrible back then. But it's not a completely novel idea either in terms of the contemporary world or historically. I cannot remember, or maybe I've written down wrong, what your third question was.
Just about broader powers, and with the president's ability to protect, could that include?
Oh yeah. So could he if he has the power to exclude hostile troops or terrorists or attack them, could he just designate this vast category of people? My answer would be no. That for some of the same reasons that I've already given with respect to sort of pretextual uses of other powers. Again, there's a difficult borderline issue in some cases, but it's not that difficult where you're faced with a situation where the risk that to look at the Trump order situation, the risk that an American will be killed by an immigrant terrorist of any kind, not just one from those 7 countries, but from all over the world, is several times lower than the risk that an American will be killed by lightning in a given year. You're essentially excluding this vast number of people to get at what is an extremely tiny number of terrorists. So it's a little bit like saying, it's not much different from saying we need to exclude everybody who might come in from this nation because otherwise at least a few of them will violate some tariff regulations, and we don't know ahead of time which ones might violate the tariff regulations. I do grant here, as in some other cases, there can be difficult borderline situations, both literally and figuratively. Once again, if we're at the point where we're arguing about where the exact border is, then I've won 80 or 90% of the ground that I'd like to win, and I'd be very happy in that situation. So I think we can move on to the next triumvirate or troika. I guess as a Russian, I like the term troika better, though it also has some negative historical associations.
These three have to be very quick. David Upham, Larry Solom, and Stephen Sachs.
I would just say that for a scholarly article, take a smaller portion and just go into all the materials. If it's more of a sort of a popular sketch or a semi-popular sketch of an argument for Constitution and open borders, maybe that's what you're trying to do. But some of this stuff, there's a lot of materials that I think you should cover just in dealing with just commerce or naturalization or other things. There's one example. The Kentucky resolution talks about the immigration importation clause, migration clause, that says it's unconstitutional at least to exclude aliens. That's another one of their arguments. Because in 1798, it's not 1808 yet. Just more generally, just as an historical matter, questioning Congress's immigration power has in fact had the effect not of restricting immigration policies, but providing a pretext or a justification for a general sort of extra constitutional powers, like Curtis Wright export and lots of others. Maybe that's not going to be the effect of your scholarship, but that's been the effect at least 100 years ago. That was the effect of those kind of challenges.
So this is just focused on your discussion of state restrictions and the power and the right of locomotion, right? So you quote Williams v. Fears, but that case was a privileges or immunities case. That's the case you quote on 31. And then on the next page, 32, you deal with this argument, and your answer is the civil rights cases of 1883, but the passage that you read does not attach this to the due process clause. So I just think you need to do some more work here on getting the right of locomotion as it applies to the states in the 14th Amendment attached to something other than the privileges or immunities clause. The argument that you make, I don't think works as a matter of the cases that you cite.
I just want to echo both of those points to say that I think that the paper would be a lot better with a lot more discussion of states, in particular evidence predating Slaughterhouse and sort of general discussion of the theory of the 14th Amendment that would go from a similar original perspective. But I just want to say one thing very quickly, picking up Michael Rappaport's question about eminent domain and everything else. if the federal government had territory lining the United States, or if it declared its ownership of the territorial sea or something like that, and then just made it a criminal offense under the Territories Clause for someone not on the approved list to pass through it with the intent to enter the United States, could they essentially recreate a federal power of immigration just by obtaining territory that surrounded the states?
So I guess I'll again take these questions in a reverse order. I think this last question is sort of another, albeit more creative version of the question I've asked several times, is sort of, could they in effect try to pretextually use other kinds of powers to accomplish this? And I think the answer, I would give the same kind of answer. With that one, it's maybe a little harder in that in a federally owned territory, the federal government would have the same kind of rights or powers, presumably, as a state would have within a state. So there, I guess I would say maybe if the federal government could build territory surrounding the U.S. And make it a federal territory, then maybe perhaps they could do it. This is an interesting legal question. I don't consider it that important for the real world because obviously we are surrounded. We have borders where there are states there, not the federal government, and we have the seas and so forth. And the federal government claiming the kind of sovereignty over the seas that a state has over state would run into a lot of problems under both constitutional law and international law. So on the issues of the Privileged Immunities Clause and the Due Process Clause, I'm not going to at this point rely on my memory of the exact passage of the case. All I would say is that it's well taken, the admonition. I should look more carefully at them and also look more carefully at some of the other evidence from 1868. One possibility I'm considering is simply just carving out the state power part of this and just focusing this paper on federal and saving the state for later. There are pluses and minuses to both of those approaches that I've discussed with Steve and others before, and I'm not yet sure which is the better path to go on that. And then I'm not sure what was the very first question in this chain. So the issue of so it's true that the Kentucky resolution has that passage that you mentioned. However, the author of the Kentucky resolution, Thomas Jefferson, also said in his initial draft of it in Elstree that there was no general power here. So I think this is an argument in the alternative that even if there is a general power, you can't exercise it yet, at least with respect to those states who want to let people in. But I think it's desirable to specify that point about the Kentucky resolution. I'm happy to do so. On your more general point of if you deny Congress's sort of specific power that was just with people to adopt the inherent power theory, obviously that did happen historically. In the paper, I criticized the inherent power theory as well, but I don't imagine that my criticism of it, no matter how good the criticism might be, will by itself cause the politics and political economy of the situation to change. That's why in the very last part of the paper, I talk about how if you want to achieve real world change in this area or in any area of constitutional controversy, you need a multi-pronged strategy of a legal analysis and a political movement. And in some of my other work on the Kelo case and public use, for example, I've talked about how this can be done. There's also a large literature on it generally, but this paper does not purport to lay out sort of a general political and legal strategy for how we get from here to where I hope we can eventually get. All I would say is that I'm very conscious of the fact that legal argumentation by itself, even the best legal argumentation, I don't claim that I'm the best legal arguer ever, but even the best legal argumentation won't get you there by itself. Rather, it has to be part of a multi-pronged strategy of the kind that we see with the civil rights movement, the gun rights movement, and others. And I hope over time that can be done in this immigration area, but this is just one part of it.